it gives the regulators, the government, basically, the power to seize documents without a warrant. That's so they can come into my office and watch me provide legal services. Can you imagine a government agent coming into your office and wanting to sit in on one of your appointments with
the client?
With the client.
So now,
and they can also enter a private residence.
Horrible.
So can you imagine if the government's at your door saying we'd like access to your record, to your residence? Are you in a position to say no? Really?
So I'm here today with Jodie Taylor, and we're going to be discussing Bill 21, which is the Legal Professions Act. My name is Roger Harrington, and we've been subjected to a thing called Bill 36, which has profound overreach implications with the healthcare professionals. And that legislation has so-called streamlined our setup so that we've gone from 20 colleges down to 6. But in addition to that, huge penalties have been put in place so that if a healthcare professional speaks out against any protocol listed by the government, there are penalties in place to put them in jail for 6 months and $200,000, or if they have a corporate structure, $500,000. So there are huge implications with this legislation. Now, I've just seen a thing called Bill 21 coming down, and as a lawyer of 20 years in the Valley, I'd be interested in the implications from your perspective.
Well, I think there's a lot of lawyers very concerned about it because there's the perception of the public and how independent a lawyer is from government. So initially, we got told at a bar conference luncheon that it was a done deal, that this was already in place, or there was not really much room for consultation, and in fact we weren't consulted at all. But it's my understanding that the Law Society now is mounting an argument against the legislation for the same reason. We're concerned about the independence of the lawyers from government, and this idea that they're reaching into every area of our lives, whereas the public has enjoyed an independent relationship or an independent legal law force, I guess. It's a bunch of lawyers.
So up until now, like many of the health professions, you were a self-regulated organization. Yeah, so we are a self-governing organization, and what that means is that when we're brought up for disciplinary action, or like if, for example, a lawyer acts in a conflict of interest situation, or someone perceives them as being in that situation, they can go in front of the Law Society and respond to a complaint about conflict of interest. And the lawyer may not agree that it's a conflict of interest, and up till now it's been a council, like a tribunal of lawyers that are actually deciding, who understand the nuances of practice, who understand the conflict rules, for example, and who understand the pressures of being in private practice and the myriad ways you could find yourself in a conflict of interest, and that's one of the things that concerns me about not being a self-governing profession, is that this act permits the government to appoint people to be the decision makers on lawyers who have no clue, who have no background in law. So
You could be in front of a tribunal that is composed of 2 non-lawyers and a lawyer, because there's usually three members in a tribunal.
Oh, okay. So it's not the entire
So someone else
panel.
would make a decision on you that has no experience in law. And that's just one area that concerns me, or concerns lawyers. But certainly with people who practice in criminal law, I don't practice in criminal law, but I mean the interests of the public and the interests of the government are not always the same.
No.
And people expect their lawyers to be independent and to be advocates for them, not to be subject to the rule of a government agency that overwatches their practice,
Okay.
watches over them, and subjects them to disciplinary actions, or policies that are government driven. And I don't personally have a lot of faith in the federal government or the provincial government at present, because of the COVID response, basically.
Okay.
Well, not just the COVID response, but that's a big thing for me.
And so what would you propose in lieu of that?
Well, I think the elected bench members who govern themselves directly is better model. It's fairer, and there's a more. I think the public will perceive it differently too.
Okay, and so would you suggest that the previous system was okay as it was?
It
that working?
It was okay, but now the government is making inroads on all the areas that affect our lives, and this may be termed like an administrative type of law, because it really affects lawyers, but there are some genuine concerns amongst lawyers that this will impact the independence of the bar and the delivery of legal services as a result of that independence or lack of independence.
So will that take away autonomy for your clients too? Or
I think if you're a lawyer and you're representing someone in court and you know that you can be brought in front of a government official who's going to decide your fate as a lawyer and the existence of your license based on whether you are advancing a client's position that doesn't accord with the government's,
that sounds pretty tyrannical to me.
I know, that's how I feel about it.
Okay, and
And the Law Society has actually, despite that bencher telling us that it was a done deal, I've set out an official statement about this this proposed bill, and they're prepared to take it to a lawsuit if necessary, if it's passed.
So no, I think there are 300 plus articles in Bill 21.
Oh, okay, right.
And then I was looking through, and I think Articles 198 through 208, they're setting forth penalties. Had you seen that?
I haven't looked at those penalties yet.
Okay, well, they're identical to Bill 36.
So if you don't agree with the government, you're subject to being fined?
2 years in the brig.
Wow.
$200,000. But it's identical in terms of the financial consequences, but also there's a 2-year prison sentence available to them to spank you with. We got off light because we only had 6 months. But,
2 years is significant. I mean, that would...
Well, I think 2 minutes in jail is way too long, especially if you're acting in the interest of your client rather than...
And I think lawyers have historically been the ones who advance charter arguments and violations of human rights, etc. Like, they are the guardians of justice. They are, because, I mean, the judges are appointed by government also. So you have the advocate who's responsible for potentially putting forth an ideology that's contradictory to the government's ideology or the government's interests, which to me have seemed most recently as though they're not following the best interests of Canadians. They're definitely following someone else's agenda, like probably the United Nations Agenda 2030 or the World Economic Forum. Like, definitely those kind of policies are being directed from on high, and they have nothing to do with Canadian jurisprudence or what the public wants.
That's very, very scary.
It is.
So.
It's Orwellian.
Oh.
They've said that.